Good morning, everyone. It's 9 a.m., so we are now officially live.
Good morning. My name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Derek Sims, inmate number 300964. Today is Monday, November 24th, 2025. This hearing is being conducted via video at the Board of Pardons and Parole Central Office in Osborne Correctional Institution. Please state your full name and DOC inmate number for the record.
Derek Sims, 300964.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is also your attorney.
Good morning, Peter Matthews, the Public Defender's Office. Mr. Sims.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not the allegation is true. If I do not find that there is preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Simons, please raise your right hand. Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yeah.
First, I will read you your rights. Then we will review the parole violation charges of the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
You have important rights of this hearing, which I now will review. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Mm-hmm.
We now will review the charges of the state your parole officer is bringing against you and the information underlying each charge. For Charge 1, GPS, and Part 1 of Charge 2, Program Participation, a no finding was made at the preliminary hearing held on October 7, 2025. The state has not provided any further evidence regarding these charges, therefore they will not be considered today. So regarding Charge 2, Program Participation, you are stipulated to participate in Behavioral Management Program for Domestic Violence. You were referred to Willard Clinic to attend the Explore program. You refused to attend the intake on August 27, 2025. The intake was rescheduled to September 3rd, 2025, which you also refused to attend. Subsequently, you were unsuccessfully discharged from Willard Clinic Explore. You are stipulated to participate in a behavioral management program for problem sexual behavior. You were referred to the Connection Center for the Treatment of Problem Sexual Behavior. You refused to attend the intake on September 2nd, 2025. Charge 3, Behavioral Management Program. You are stipulated to participate in a behavioral management program for domestic violence. You were referred to Willard Clinic to attend the Explore program. You refused to attend the initial intake on August 27th, 2025. The intake was rescheduled to September 3rd, 2025, which you also refused to attend. Subsequently, you were unsuccessfully discharged from Willard Clinic Explore. Charge 4, Halfway House Placement. On August 15th, 2025, during the intake at Stein House, you refused to speak to Halfway House staff, resulting in them not being able to complete the required intake process. On August 15th, 2025, you became agitated and began yelling at Halfway House staff and had to be asked to leave the room. While doing so, you aggressively slammed the office door while yelling at staff. On August 18th, 2025, you were unaccountable in the community. You were issued a pass from 11 a.m. to 1 p.m. to go to and from the Hartford District Parole Office. No other locations. Upon leaving the parole office, you failed to return directly to the Halfway House. You left the parole office at approximately 1:40 p.m. and failed to return to the Halfway House until approximately 5:38 p.m., 4 hours later. Your whereabouts were unknown for approximately 4 hours. The travel time between the Hartford Parole Office and the Halfway House is approximately 30 minutes to 60 minutes. Charge 5, problem sexual behavior treatment. You are stipulated to participate in a behavioral management program for problem sexual behavior. You are referred to the Connection Center for the Treatment of Problem Sexual Behavior. You refused to attend the intake appointment on September 2nd, 2025. The state's exhibits were marked and identified at the preliminary hearing held on October 7th, 2025. You received the notice of parole violation report, and other documents that were marked for identification purposes.
Yes, I did.
Today we have no witnesses. It is now the defense opportunity to present evidence, speak to any of the evidence submitted. Counsel?
Thank you. I did speak to Mr. Symes. He did indicate to me that he did participate in all the counseling and treatment that was required of both parole and the halfway house. Unfortunately, I wasn't able to get a lot of details regarding his version of events due to some of the challenges he is facing. I will say there's no new criminal conduct. None of the alleged violations rose to the level where police intervention was required. A lot of the allegations we cited in the PBR narrative, I know it's very lengthy, they're quite dated, and they're not included in the charges that Mr. Symes is currently facing, which are much more narrow. Mr. Sims, is there anything you want to say about the charges right now?
No.
If there was a finding made, I would like to hear something about the sanction. Thank you.
Thank you. As stated, regarding charge 1 GPS, no finding was made at the preliminary hearing held on October 7th, 2025, and no further evidence was submitted regarding this charge. Therefore, it's not being considered. Regarding charge 2 program participation, a no finding was made on part 1 at the preliminary hearing held on October 7th, 2025. And again, no further evidence was submitted regarding this charge. Therefore, it's not being considered. However, I do make a finding on parts 2 and 3 based on state's exhibits C, D, and H through L. Charge 3, behavioral management for domestic violence. I make a finding based on state's exhibits C, D, and H through L. Charge 4, active house placement. I make a finding based on state's exhibits C, D, E, G, H, and L. And charge 5, problem sexual behavior treatment. I make a finding based on state's exhibits C, D, K, and L. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney will have an opportunity to speak to your background and history. Counsel?
Thank you. As I indicated at the preliminary hearing, I did review the long narrative in the PBR, and I do think this is an exceptionally sad circumstance here. Mr. Sims is clearly struggling. I will say he does have a family who loves him very much and does want him to do well. Clearly, he has not done well in the halfway house environment. I just think a halfway house is going to be very difficult for someone like Mr. Sims. I do want to stress, I don't think this is a situation of Mr. Symes just being intentionally obstinate or difficult. As I indicated when he was initially released, DIS gave him a mental health score of 1. Based upon the allegations and descriptions in the PBR, I do think something has fundamentally changed. At some point in the past, Mr. Symes has been able to hold down jobs and work to support himself. I know according to the DIS, he worked in security and he worked in restaurants for several years. I will also note that he appears to be cooperating with corrections. He hasn't picked up any DRs in several years now. He was initially put on special parole in 2020, and it looks like initially he was doing well for several years. He didn't have any problems up until 2023. So he went 3 years there where he was able to cooperate with parole and work with them effectively. At some point in the past, he had been able to hold down employment and cooperate with parole. The onset of these difficulties do appear to be fairly recent within the past couple of years. I do think that Mr. Symes is someone who needs help, and I don't think the halfway environment that he was in was providing him with the kind of help and care that he needs. But I think he's demonstrated an ability to do it in the past. I'm hoping in the future, if he gets the right treatment and the right course, maybe he can get back on the right track and try to, get back where he can get a job and he can support himself and do well. That's what he wants. That's what his family wants for him. Mr. Symes, is there anything you want to add?
No.
And regarding if parole is reinstated, what would be his release plan?
Mr. Symes, if you're released, where would you like to go? What would your release plan be? If you were released, where would you like to reside?
In a home.
I know his family does live out of state. Would you need a halfway house in Connecticut, Mr. Siles?
No.
Anything further, council?
No, nothing further.
Okay. I'm just gonna take a moment before I announce my recommendation. Okay, Mr. Simons was discharged to special parole in December of 2020. Since being discharged to special parole, he's received 3 prior parole violations, this being his 4th parole violation. Taking into consideration that this is his 4th parole violation and the nature and circumstances of this violation, I recommend revoke with no new re-parole date, which is an approximate 15-month sanction. In the event the board lessens the recommended sanction, I recommend the following conditions: no consumption of alcohol, behavioral management for domestic violence, no contact with victims I, M, and J and KJ, a general no contact with Colleen Monahan and Elizabeth Russell, halfway house placement, mental health evaluation, no contact with minors without the express permission of your parole officer, and problem sexual behavior treatment. My findings and recommendations will be forwarded to the board, and the board review is scheduled on December 4th, 2025. And on that date, the board is going to make the final decision. So that does conclude the revocation hearing. Thank you, Mr. Symes. You're all set. Thank you.
You're welcome.
Good morning.
Hi, good morning.
We should have Mr. Pierce and Mr. Jones.
Yes, they're both here.
Perfect. We can start with Mr. Pierce.
Okay, thank you. Pierce?
Good morning, Mr. Pierce.
Good morning.
We're going to get started in a few minutes.
All right.
Morning, my name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Jerry Pierce, inmate number 255323. Today is Monday, November 24th, 2025. This hearing is being conducted via video at the Board of Pardons and Parole Central Office in Robinson Correctional Institution. Please state your full name and DLC inmate number for the record.
Hi, my name is Jerry Pierce. My inmate number is 255323.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is also your attorney.
Good morning, Peter Matthews, with Public Defender's Office to Mr. Pierce.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Pierce, please raise your right hand. Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Correct.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, your attorney will have an opportunity to speak to your background and history. Mr. Pierce, do you have any questions about the purpose or procedure before we begin?
No.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. And Mr. Pierce, did you receive the evidence packet that had all the charges and the supporting documentation to follow?
Yes.
You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Correct. Yes.
We now will review the charges that the state your parole officer is bringing against you and the information underlying each charge. Charge 1, drug testing. On June 26, 2025, you were directed by the staff at the Steen Halfway House to render a urine upon your arrival to the halfway house from McDougal. You informed staff that you would not be rendering a sample. This behavior places you in clear and direct violation of your signed parole conditions, specifically under drug testing, as you were instructed to submit to testing, were made aware of the instructions, and you still refused to submit as instructed. Charge 2, absconder. On August 11th, 2025, staff at the Eddy Center Halfway House reported that you were not present or accounted for during an 8:50 p.m. head count. Another resident subsequently reported they overheard you on the phone asking the person you were on the phone with to pick you up around the corner. You then exited the area through the back gate with a backpack. Your parole officer attempted to locate you via phone directly and to other sources on August 11th, August 12th, August 14th, and August 15th, August 19th, and August 21st, 2025, as well as in addition to an attempt to physically locate you in the community on August 21st, 2025. Your whereabouts in the community were unknown. Charge 3, obedience to the law. On August 5th, 2025, you became a subject in an investigation and attempts to mail K2 into McDougal Correctional. Upon an extensive investigation, it was discovered that you were deceitful to your previous PO in order to obtain a transfer to a halfway house to work in your favor of being able to do illegal activities. Through various text messages to a third party, you were then able to communicate with an inmate at McDougal and detailed that you purchased cards, sprayed the cars with K2, and were seeking a pass from the halfway house to be able to mail the contraband. Your behavior is comparable to a violation of Connecticut General Statute 53A-48 conspiracy, as the statute has three elements, which are an agreement to act upon this agreement and intent. You had an agreement with this inmate to manufacture K2. You acted on said agreement by reporting you made the purchase and sprayed K2 onto cards, and you intended to mail the K2 to this inmate. This behavior is clear and a direct violation of your signed parole conditions. Charge for halfway house placement. On July 19th, 2025, you were issued a pass to visit your father at Hartford Hospital. You exited the halfway house at 10:45 a.m. and were due back for 2 p.m. You failed to report back until 3 p.m. Upon further investigation, it was determined that you also did not go to the Hartford Hospital at all, therefore making you unaccountable in the community for approximately 4 hours and 15 minutes. On July 29th, 2025, halfway house staff conducted a pat and pocket search of your person and subsequently located a vape. On August 11th, 2025, staff at Eddy Center Halfway House reported that you were not present or accounted for during an 8:50 p.m. head count. Another resident subsequently reported that they overheard you on the phone asking the person you were on the phone with to pick you up around the corner. You then exited the area through the back gate with a backpack. The state has filed the following exhibits. Exhibit A, parole and community services conditions. Exhibit B, halfway house agreement. Exhibit C, incident report. Exhibit D, offender misconduct. Exhibit E, PCS conditions. Exhibit F, halfway house agreement. Exhibit G, incident report. Exhibit H, offender misconduct. Exhibit I, incident report. Exhibit J, offender misconduct. Exhibit K, offender misconduct. Exhibit L, halfway house agreement. Exhibit M, incident report. Exhibit N, email from McDougal. Exhibit O, 13 screenshots. Exhibit P, remand to custody order. Exhibit Q, notice of parole violation. Exhibit R, notice of parolee rights. And Exhibit S, parole violation report. Council, did you receive the notice of parole violation report, and other documents that were just marked for identification purposes?
I did.
Defense has also filed parole accomplishments and future plans for parole reinstatement. Today, we have no witnesses. It is now the defense opportunity to present evidence to speak to any of the evidence submitted. Counsel?
Thank you. With regard to charge 1, I did review Exhibit C and spoke to Mr. Pierce about this charge. Mr. Pierce indicated he initially refused a urine test because he didn't feel comfortable with the procedure of someone watching him through a mirror in the bathroom. Ultimately, he did complete the urine test that day, so while he may have initially had some concerns about the process of the urine test and he had just arrived at the halfway house and was unfamiliar with their procedures, he ultimately did take the urine test that same day. Charge 2, the allegation that he absconded from the halfway house, Mr. Pierce did indicate that he had some safety concerns that ultimately led him to making some poor decisions regarding leaving the halfway house. He indicated he was being threatened by some individuals he knew from when he was incarcerated, and this did lead him to leave the halfway house. And Mr. Pierce is apologetic and regretful about this conduct on his part. Charge 3, obedience to the law. I would ask that no finding be made with regard to this charge. To begin with, Mr. Pierce was never arrested for any criminal conduct regarding these allegations. There was never any illegal material attempted to be transported anywhere. The basis of the charge are some text messages, which ultimately never led to any action by Mr. Pierce or resulted in any arrest for his conduct. I would further argue that the allegations that he's in violation of 53A-48 conspiracy doesn't really make sense from a legal perspective. Conspiracy is not a criminal violation in and of itself. Someone can be convicted of conspiracy to commit assault, conspiracy to commit burglary, or some other crime. But simply saying that Mr. Pierce is in violation of conspiracy doesn't really make sense. You can't be convicted of just conspiracy. The allegation here is legally insufficient since there's no underlying criminal statute cited that Mr. Pierce is alleged to have conspired to violate. Finally, with regard to charge 4, Mr. Pierce does deny the allegation that he never went to the hospital. He did indicate that he went to the hospital to visit his father that day, so he doesn't dispute that part of the charge. With regard to the vape possession on July 29th, I would just note the device was a nicotine vape. Mr. Pierce did not possess any illegal substances or marijuana at the time. I don't think there were any positive drug tests ever for any type of marijuana or any illegal substance on his part while he was at the halfway house. If there is a finding made on any of these charges, I would like to be heard further with regard to sanction. Thank you.
Thank you. I'm going to take a moment before I announce my findings. Regarding charge 1 drug testing, I make a finding based on state's exhibits A, C, D, and S. Charge 2 absconder, I make a finding based on state's exhibits A, E, M, and S. Charge 3 obedience to the law, I make a no finding as the state failed to provide sufficient evidence to prove Mr. Pierce's actions meet the elements of this charge. And on charge 4, halfway house placement, I make a finding based on state's exhibits A, B, E through I, J, L, M, and S. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney will have an opportunity to speak to your background history. Counsel?
Thank you. So Mr. Pierce, he's 44 years old. He was born and raised with his family in Connecticut. His family, including his mother, his father, and his sister, they still reside in the Hartford area. He has 2 children who are teenagers now, and he has another child on the way. He does have a lot of support from his family, and they are looking to help Mr. Pierce and contribute to his success going forward, both on and off parole. I know his father has been suffering from some medical issues for an extended period of time now. He had a stroke and he's in a rehab facility right now, but his other family are in Hartford and willing and able to help him and assist him. Mr. Pierce has been hoping to be sponsored by his sister, who does reside in Hartford. He is hoping to avoid having to go to a halfway house if possible, as he has not really done great in the halfway house environment, most likely due to his fairly significant mental health issues, and feels he'd be more likely to succeed on parole if he could be sponsored by his sister, who he has a very close relationship with, and she can help assist him with his obligations. Prior to his remand, Mr. Pierce was employed at R Men's Fashion in Hartford. He did have a good relationship with his employer. He assisted with cleaning, general maintenance, and sales, and he's hopeful that in the future he will be able to go back to that position. He has generally had success in finding employment while he's been on parole, and if he can't go back to that position at R Fashion, he is fairly confident he will be able to find another position without too much difficulty. While he was on parole, Mr. Pierce was referred to the Explore program. He had successfully completed the Explore program at one point in the past on parole, but he was re-referred after being released again, and he did start the first few sessions here. He tells me he was not referred to any type of mental health counseling or treatment, but he does want to engage in mental health counseling. Since he's been remanded, he's been assigned to a mental health counselor, and he is on medication, which he is complying with at this time. He does indicate he has a significant mental health diagnosis, and that has contributed to a lot of the problems he's had on parole. I know this is his 3rd violation, and he has had some struggles with parole supervision. I would know he didn't manage to complete 17 months of supervision prior to his 1st violation, but I do understand he's absconded in the past, and his periods of supervision have not been particularly lengthy. Dealing with his mental health diagnoses has been difficult. Residing in a halfway house on parole can be a stressful environment for someone with these type of mental health challenges, and I know he's not done well in the halfway house environment, but he's hopeful if he can change and reside with his sister in a more comfortable and supportive environment, he's hopeful to be able to do better on parole going forward in the future. Even if he's not a halfway house, Mr. Pierce certainly understands he's going to have a lot of treatment obligations, and he does want to engage in treatment, both substance abuse and mental health counseling. And he understands that engaging with this and complying with the treatment is going to be essential for him staying on the right path and avoiding difficulties going forward. As I indicated, he has shown some ability to work with parole. He did the 26-week Explore program, which is a very lengthy program, and he was able to complete that in the past. I know the parole recommendation was 12 to 18-month sanction. I suspect this is based on the fact that he hasn't done well in the past on the past couple of violations with absconding, but I would ask you to consider a lesser sanction of 6 to 8 months. We certainly appreciate that some sanctions are appropriate given his history, but he has a lot of issues which he's facing, which does make it difficult for him to succeed on parole. I would also note that there was a no finding on the obedience to law charge, which was probably the most serious alleged violation other than the absconding here. So I do think that should have some bearing on the recommendation which is made at this hearing as well. Mr. Pierce, is there anything you'd like to add at this point?
No, I just would like to know, if I think it'd be best for me to go to my sister house and go to a halfway house, and because I know my mom and my sister can help me out with the mental health thing, because when I was talking to my parole officer, telling my parole officer about my mental health, I needed to see a counselor. She was saying like, no, do the Explore program first. Don't worry about the mental health thing. And I was like, trying to explain to her, like, when I was incarcerated, I was going through mental health. I had a mental health counselor. She's like, oh, you can talk to me if you got a problem. I'm like, no, it's different. You're my parole officer. I had a mental health counselor that I met with every other week. So she wasn't like, her and my mom was crashing on that. And she wasn't taking it serious, I guess. So.
Thank you. Any further?
Nothing else to add, no.
I'm going to take a moment before I announce my recommendation.
All right.
Okay, Mr. Pierce, I see that you were discharged to special parole in March of 2022. Since being discharged to special parole, this is your third violation and your third time of absconding from parole. And you also have one prior criminal violation. Regarding this violation, you were in the community for approximately six weeks before absconding, and then your whereabouts were unknown for approximately an additional 6 weeks. So taking into account the nature and circumstances of this violation, as well as your history since being on special parole since 2022, I recommend revoke and reparole on March 25th, 2027, which is an approximate 18-month sanction with the following conditions: no consumption of alcohol, behavioral management for domestic violence, no contact with victims BD, SW, and TGM, a general no contact with Chanel Johnson and Virgil R, mental health evaluation, and no operation of a motor vehicle without the express permission of your parole officer. My findings and recommendations we forward to the board. Your board review is scheduled on December 4th. So on December 4th, 2025, the board is going to review your case. My recommendation is a 18-month sanction. The board can lower that recommendation, or they can adopt that recommendation, or they can exceed that recommendation, being that you remain on supervision until September of 2030. But whatever the board decides, you're going to receive in writing. Okay.
All right.
So that does conclude your revocation hearing.
So I'll do 18 months.
If the board agrees, the board can go lower. They could agree with the 18 months, or they can exceed that recommendation, being that you still have supervision until 2020.
You'll make a decision on December 4th, Mr. Pierce.
Right.
You'll get something in writing after that.
All right.
Thank you. Good morning. My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Jermaine Jones, inmate number 324957. Today is Monday, November 24th, 2025. This hearing is being conducted via video at the Board of Pardons and Parole Central Office in Robinson Correctional Institution. Please state your full name and DOC inmate number for the record.
Jermaine Jones, 324957.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is also your attorney.
Good morning, Hannah Jean on behalf of Mr. Jones.
This is a revocation. This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Jones, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Thank you very much. First, I will read you your rights. Then we will review the parole violation charges that the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, your attorney will have an opportunity to speak to your background and history. Mr. Jones, do you have any questions about the purpose or procedure before we begin?
No.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. And Mr. Jones, did you receive the evidence packet that had the charges and the evidence?
Yes.
You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes.
We now will review the charges that the state your parole officer is bringing against you and the information underlying each charge. Charge 1, obedience to the law. On March 27th, 2025, Norwich Police Department observed what appeared to be a narcotics transaction in the vehicle you were a passenger in. A K-9 was utilized to detect narcotics on the passenger side of the vehicle to which you were seated. On search of the vehicle, the following was found: 3 cardboard boxes. Box number 1 contained a clear plastic bag containing a purple-colored powder-like substance, fentanyl, weighing 9 grams, including packaging materials. The other 2 cardboard boxes contain numerous unused wax paper folds, which is a known item typically used for packaging fentanyl. A search of the passenger side door floorboard yielded a black plastic bag. Inside this bag was a clear plastic bag containing 9 smaller, clear knotted baggies, which contained a rock-like substance, crack cocaine, weighing 38 grams, including packaging. Inside the black plastic bag was 230 white-colored wax folds, each containing purple-colored powder, material weighing 51 grams, including packaging. Based on the crack cocaine and fentanyl being separated into smaller individual bags prepared for street sales, it was evident that you were selling crack cocaine and fentanyl. The amount seized was greater than for personal use. A search of your person yielded $632. Both the crack cocaine and fentanyl were field tested with positive results. Once in booking, you admitted to Norwich Police Department that the narcotics were yours. Based on your actions, you were subsequently arrested for 2 counts of unauthorized possession of controlled substances and 2 counts of possession of narcotics with intent to sell. Charge 2, drugs. On March 27th, 2025, Norwich Police Department observed what appeared to be a narcotics transaction in the vehicle you were a passenger in. A K-9 was utilized to detect narcotics on the passenger side of the vehicle to which you were seated. Upon a search of the vehicle, the following was found: 3 cardboard boxes. Box number 1 contained a clear plastic bag containing a purple-colored powder-like substance weighing 9 grams, including packaging materials. The other 2 cardboard boxes contain numerous unused wax paper folds, which is a known item typically used for packaging fentanyl. A search of the passenger side floor board yielded a black plastic bag. Inside this bag was a clear plastic bag containing 9 smaller, clear knotted baggies, each containing a rock-like substance, crack cocaine, weighing 38 grams, including packaging. Inside the black plastic bag was 230 white-colored wax folds, each containing purple-colored powdered material weighing 51 grams, including packaging. Based on the crack cocaine and fentanyl being separated into smaller individual bags prepared for street-level sales, it was evident that you were selling crack cocaine and fentanyl. The amount seized was greater than for personal use. A search of your person yielded $632. Both the crack cocaine and fentanyl was field tested, which yielded positive results. Once in booking, you admitted to Norwich Police Department that the narcotics were yours. Based on your actions, you were subsequently arrested for 2 counts of unauthorized possession of controlled substances and 2 counts of possession of narcotics with intent to sell. The state has filed the following exhibits. Exhibit A, signed statement of understanding and agreement of conditions of parole. Exhibit B, remand to custody order. Exhibit C, violation notice of parole. Exhibit D, parole violation report. Exhibit E, BOPP disposition summary. Exhibit F, police report, City of Norwich. And Exhibit G, judicial branch printout. The state has filed an addendum to Exhibit D, which states on October 22nd, 2025, Mr. Jones was convicted of 1 count of sale of narcotic substance and was sentenced to 5 years jail, execution suspended after 2 years jail, followed by 2 years probation. The charges of 2 counts of unauthorized possession of a controlled substance and 1 count of possession of narcotics with intent to sell was dismissed under docket ending in 416. Counsel, did you receive the notice of parole violation report, and other documents that were just marked for identification purposes?
We have, yes.
Defense has also filed Exhibit 1, parole accomplishments and future plans for parole reinstatement. Today we have no witnesses. It is now the defense opportunity to present evidence to speak to any of the evidence submitted. Counsel?
Thank you very much. Concerning the charges, we don't have anything to note aside from just indicating that the addendum recited was accurate. My client received the 5 years suspended, 2 years to serve, 2 years probation. All other charges were dismissed, and we would like to speak to his background at the appropriate time.
Thank you. Regarding charge 1, obedience to the law, I make a finding based on Mr. Jones' conviction, as well as states exhibits A, D, and F. Charge 2, drugs, I make a finding based on Mr. Jones' conviction, as well as states exhibits A, D, and F. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney will have an opportunity to speak to your background and history. Counsel?
Yes, thank you very much. My client, Mr. Jones, is 44 years old, born and raised in Hartford. His primary support in the community is his mom, his oldest child, and many long-term friends. My client has a biological child and 1 stepchild, both of whom reside in state. There is reportedly involvement with DCF out of New Britain, as my client's mom has an open case. So I know my client is very eager to get out to be there for his young child. Upon release to community release in September of 2024, my client utilized Sierra Center. He successfully completed Watkinson House and then was sponsored at a private residence in Hartford. Previously, while incarcerated, my client received his CCAR certification to become a recovery coach. He has 2 additional phases to complete, but he has done the main part of the program and is ready to take the steps he needs to further those other 2 steps. My client reports that he received his flagging certification through complete labor and staff. He reports that he was set up to begin the Best Chance for a Second Chance program to study construction. He reports being employed full-time at Quality Lumping Service and Aldi Distribution in South Windsor for about 4 months. He reports having another out-of-state opportunity, but was unable to be granted travel for it. On April 14th, 2025, my client did an intake at Wheeler, was not recommended to further treatment at that time. Prior to transitioning to Robinson Correctional, my client reports being employed as a tierman at Corrigan. Reinstatement of special parole, he would like to be placed at his sponsor in East Hartford. That is his mother's address that we provided. He hopes to engage in the Best Chance program, again, to do construction. He's interested in working for a business that he and his friend established called Freeway Logistics. And in the meantime, he's available to any available opportunities. He's very eager, as I noted, to get out and provide for his young daughter, and he's open to any sort of treatment recommended for him. I am asking that you consider the earliest possible release date or the MOA date for my client. That would still be, I would argue, a significant sanction of over a year. And that would be upon community release's discretion. So certainly, he would have to show that he is doing what he needs to do in order to earn that. He has been incarcerated since March of this year. I know he's, as I noted, very anxious to get home to his children. Mr. Jones, is there anything I didn't indicate that you want to state for the record at this time? You don't have to. It's just if there's anything I didn't cover.
No, you pretty much covered it.
Thank you very much. Great, thank you.
Thank you. I'm going to take a moment before I announce my recommendation. Mr. Jones, I see that you were released on community release in September of 2024. Although you did discharge to special parole in January of 2025, but you were in the community for approximately 6.5 months prior to this new arrest. Taking into account this is your first parole violation and receiving the 2-year sentence, I recommend revoking reparole on March 26, 2027, which is an approximate 2-year sanction and coincides with your new criminal conviction. I recommend the following conditions: no contact with co-defendants Miranda Young, general no contact with Jakara Hayes and Ricardo Garcia, and MOA in the event that the board lessens the recommended sanction. My findings and recommendations will be forwarded to the board, and you'll receive the official written decision from the board, and your board review is scheduled on December 4th, 2025. So on December 4th, 2025, the board is going to review your case. My recommendation is that you go to the end of sentence on this new criminal conviction, but they make the final decision on December 4th. So whatever the board decides, you'll receive in writing.
Mr. Jones, I can schedule, or if you would like to call my office on either that Thursday or Friday afternoon, either myself or one of our secretaries will be able to tell you what the board's decision is, okay?
Okay, so the decision right now is end the sentence?
Yes, it is until 2027, March 2027. So that new case where you got the 2 years to serve, her recommendation is that you just sit until that case sentence is done, and then you would get out for the remainder of your special parole. That recommendation she just made has to get voted on by the parole board. So it's going to go to the parole board on the 4th of December. And that morning, we should know for sure what they decided. They could potentially give you less time. They could potentially give you more time, but we'll know for certain on that day, okay?
Thank you.
Thank you very much, Mr. Jones. Have a great day and happy holidays.
Bye.
Good morning.
Hey, good morning. What do you want first? I have a Trip and a Flores both scheduled at the same time.
Yeah, trip first would be great.
Okay, yeah, they're on their way down now. I'll be here like 2 seconds.
No problem. Thank you.
All right, no problem. Thanks. So you see right there, they're already there. They're ready to go.
Good morning, Mr. Tripp. We'll get started in about 5 minutes.
Yes, ma'am.
Good morning, P.O. Kwasnick.
Good morning.
Good morning. My name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Dreams Trip, inmate number 302911. Today is Monday, November 24th, 2025. This hearing is being conducted via video of the Board of Pardons and Paroles Central Office and Cybolski Correctional Institution. Please state your full name and DOC inmate number for the records.
James Tripp, 302-911.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is your attorney,
Good morning, Hannah Dean on behalf of Mr. Tripp.
as well as your parole officer. Please introduce yourself for the record.
Good morning, Dennis Kwasnick, Parole Officer 2, State of Connecticut.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Tripp and P.O. Kwasnick, please raise your right hands. You solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury.
Yes.
Yes.
Thank you very much. First, I will read you your rights. Then we will review the parole violation charge that the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. Your attorney, as well as the state, will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, your attorney will have an opportunity, as well as the state, to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
Thank you. You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence to support your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes, ma'am.
We now will review the charges that the state your parole officer is bringing against you and the information underlying each charge. P.O. Kwasnick, starting with charge 1 GPS.
Charge 1 GPS on July 23rd, 2025. A GPS unit was installed on your person. You initialed and signed the GPS monitoring agreement indicating that you read and understood it. You subsequently violated your GPS monitoring agreement with the following GPS violations. On July 24th, 2025, you never returned to your approved residence between 9 p.m. and 6 a.m. On July 25th, 2025, you never returned to your approved residence between 9 p.m. and 6 a.m. On July 26th, 2025, your battery was dead for 7 hours, 22 minutes, 5 seconds, and you never returned to your approved residence for 37 hours, 52 minutes, and 17 seconds. On July 27th, 2025, your battery was dead for 31 hours, 39 minutes, and 44 seconds. On July 29th, 2025, your battery was dead for 3 hours, 47 minutes, and 49 seconds. On July 31st, 2025, your battery was dead for 4 hours, 54 minutes, 53 seconds. On August 1st, 2025, you arrived home at 10:22 p.m., 1 hour and 22 minutes after curfew. On August 2nd, 2025, your battery was dead for 2 hours, 27 minutes, 13 seconds. On August 6th, 2025, your battery was dead for 1 hour, 52 minutes, and 56 seconds. On August 7th, 2025, your battery was dead for 49 minutes, 46 seconds. On August 8th, 2025, you arrived home at 9:57 p.m., 57 minutes after your curfew. On August 9th, 2025, you arrived home at 10:09 p.m., 1 hour, 9 minutes after your curfew. On August 10th, 2025, your battery was dead for 15 minutes, 38 seconds. On August 15th, 2025, you came home at 12:33 a.m. On August 16th, which was a 3 hour and 33 minutes after your curfew. On August 21st, 2025, your battery was dead for 12 hours, 8 minutes, 39 seconds. On August 24th, 2025, your battery was dead for 12 minutes, 8 seconds. On August 28th, 2025, your battery was dead for 15 minutes, 29 seconds. On August 29th, you did not return home between 9 p.m. and 6 a.m. On August 30th, you never returned home between 9 p.m. and 6 a.m. On August 31st, you never returned home between 9 p.m. and 6 a.m. On September 1st, 2025, your battery was dead for 4 hours, 33 minutes, 39 seconds, and you never returned home between 9 p.m. and 6 a.m. On September 2nd, 2025, you never returned home between 9 p.m. and 6 a.m. On September 3rd, 2025, your battery was in violation as of 4:26 p.m. after he was explicitly instructed to charge the unit immediately on September 3rd, 2025 at approximately 4 o'clock by myself. Charge number 2 is curfew. On the following dates, you did not go to your approved sponsor at all between the hours of 9 p.m. and 6 a.m. July 24th, 2025, July 25th, 2025, August 29th, 2025, August 30th, 2025, August 31st, 2025, September 1st, 2025, September 2nd, 2025, and on the following dates, you were late coming home to your approved residence after your 9 p.m. curfew. August 1st, 2025, again, 1 hour and 22 minutes late. August 8th, 2025, 57 minutes late. August 9th, 2025, 1 hour and 9 minutes late. August 15th, 2025, 3 hours and 33 minutes late. Charge 3 is program participation. On September 3rd, 2025, you were instructed to report to the App Foundation by 12 p.m. on September 4th, 2025. You signed a misconduct acknowledging the instructions to report. On September 4th, 2025, you failed to report to Apt as directed. On May 5th, 2025, you were told to get an evaluation and chose McCall, but did not schedule an appointment. On June 2nd, 2025, you stated you were in a substance abuse treatment with MCCA, a claim that was later proven to be false. On July 28th, 2025, you were told to go to McCall for a substance abuse evaluation, but did not go. On August 7th, 2025, you were told to go to McCall for a substance abuse evaluation, but did not go. And on August 18th, 2025, you were told to go to McCall for a substance abuse evaluation, but did not go. Charge 4 is residence. On August 29th, 2025, you were not at your approved sponsor and did not return for 6 days. On September 3rd, 2025, you admitted that you were no longer living at your sponsor's residence. You failed to notify me that you were no longer living at your approved sponsor's residence. Charge 5, drugs. On August 18th, you produced a urine sample that screened positive for cocaine. You denied use and requested it be sent to Premier Biotech Labs for analysis. On August 22nd, 2025, the urine sample tested positive for the presence of cocaine. On September 3rd, 2025, you produced a urine sample that screened positive for cocaine. You signed a misconduct acknowledging that you used cocaine. And I believe that's the last of the charges.
Yep. The state's exhibits were marked and identified at the preliminary hearing held on October 7th, 2025. And counsel, did you receive the notice of parole violation report, and other documents that were marked for identification purposes?
We have, yes.
Defense has also filed Exhibit 1, parole accomplishments and future plans for parole reinstatement, and Defense Exhibit number 2, ED records. Today, we have no witnesses. At this time, the state will have an opportunity to present evidence to speak to any of the evidence submitted. Peel Kwasnick?
Just to recap, for my testimony at the preliminary hearing, Mr. Tripp is being violated today because of repeated drug use and suspected drug dealing. He was given ample opportunities to attend substance abuse treatment programs. Multiple instructions were given to him, and he just failed to attend, and it took several months for him to finally attend. He tested positive for cocaine again in July, a couple times in August, September 2025, tested positive for cocaine again. When I confiscated his cell phones and went through them, there was text messages on his seized phones that contained terminology consistent with drug dealing, including discussions of drug prices, quantities, 40s, 30s, 20s, half ball, grams, a ball of suspected cocaine. Some of them he was offering to trade food stamps for drugs, sexual favors for drugs. It's basically the same criminal activity, same criminal behavior, selling cocaine, marijuana, which is why he is already on parole when he was selling marijuana while he was on probation. Graduated sanctions were attempted. Numerous graduated sanctions were attempted, I should say. Chronic GPS and curfew violations. His performance on GPS was frankly one of the worst performances of an offender that I've ever had in my 23 years with the state. Repeated failure returning home. He was installed the GPS. He didn't even bother going home for like the first 3 or 4 days that he was on GPS. He let that thing die for days on end. Numerous warnings and misconducts were issued for him for allowing for his GPS unit's battery to die for extended periods, despite explicitly being instructed to charge it. He disregarded curfew several times. In terms of his residence and non-compliance with supervision, He lost his residence at the very end. I suspected he wasn't living there before. We've had numerous informal conversations about it. Again, he was dishonest about his living situation. He was asked to leave his girlfriend's sponsor's residence in March 2025, later admitted on September 3rd that he was no longer living at his sponsor's residence. He didn't notify me that he was not living there. Attempted to pay the sponsors. His text messages that we were going through shows that he was actually paying his approved sponsor to live there. He also has text messages asking a female if he could live with her, and he would pay her to be her sponsor, or pay her to be his sponsor, I should say. He repeatedly failed to report on multiple occasions. And then, I just received the evidence for his hospital stay on the date in question this morning at 8:30 a.m. So I just had the opportunity to review it. And he was instructed to go to the App Foundation again as a graduated sanction for his drug use, and to be at the App Foundation before noon. He called me, I believe, at 2 o'clock to inform me that he was involved in a car accident at 11 in the morning. Couldn't give me any details of where the car accident occurred. Couldn't give me any details if police were called. He said that he was going to the hospital. The paperwork I received shows that he went to the hospital at 5:35 p.m. Again, 6 hours after this car crash allegedly occurred. 3 or 4 hours after I called him and said, "Why aren't you at the App Foundation right now?" A review of his text messages that day show that he was trying to purchase a car out of state, trying to line up sex with other females while he was, out and supposed to be at the App Foundation. Just basically, his cell phone and the text messages provided are just riddled with criminal activity. Again, the same type of criminal activity that he's on parole for. Again, he wasn't caught. I can't prove that he was selling drugs, but the preponderance of the evidence, I think any reasonable and prudent person would think, given the evidence that's provided, that's obvious that this man was engaging in criminal activity, drug use. There is also, I talked to the victim who doesn't want to press charges anymore, but the sponsor that he was living with, Homeland Security, was involved. They were contacted. They have the text messages, some of which are provided, where he's engaging in a pattern of threatening and harassing his ex-girlfriend, including threats of physical violence and contacting her at a workplace. It's a serious public safety concern. I understand he did complete Explore. Doesn't seem that he learned all that much from Explore if he's still engaging in this type of behavior. And just to conclude, his overall risk assessment score is in the very high range of recidivism. He has numerous serious and repeated violations. It demonstrates that the premise of parole, that he's going to remain at liberty without violating the law, is no longer valid. That's why the state is requesting a sanction of at least 6 months. Again, this is discretionary parole too, so it is a blessing that he was granted to do the rest of his criminal sentence out in the community, but his behavior has shown that it's no longer compatible with the welfare of society.
Thank you. Counsel?
Yes, thank you. Noting that we did previously on October 7th have a preliminary hearing, I don't want to take this time to belabor all the comments that were made at that hearing, as I know that those are currently already made part of the record. So I would just note that I would incorporate the comments made by both myself and my client at that preliminary hearing on October the 7th. In addition to new arguments concerning the program participation charge, I just want to reiterate, the screenshots submitted alone are not sufficient evidence for the charge, especially given the fact my client had disclosed he was using a different device that day because he did not have his, and the data for that other device is not in evidence here. I also want to reiterate, these are technical charges that we're looking at this time. My client was not charged with an obey all laws charge. Certainly if he had, I think maybe the comments concerning criminal activity would be more appropriate. However, I just want to note that we're not here because my client violated the law. We're here on technical charges. Additionally, I just want to note, I did submit the hospital records to indicate that when my client was seen, he did have a number of things flagged as irregular, including his blood pressure, his pulse, his mean arterial pressure. My client does suffer from some medical issues, most notably diabetes, which can affect many different aspects of somebody's health. So I just want to make it clear that in no way, do I think my client was malingering on the day in which he wanted to go to the hospital. I believe he genuinely was feeling unwell and wanted to be checked out. And I think that the medical records submitted do support that. Furthermore, I didn't submit this this last page, but think it's somewhat relevant just due to what was put on the record. Just to note, my client did initially arrive at the emergency room at 3:12 p.m. I do have the records here. I'll note, I apologize for not sending that page as well. I thought that it was included. He was initially seen at 3:12, was dismissed, I believe, at 4 o'clock, but then was later seen for a more thorough evaluation shortly thereafter. And those are the records that I had submitted as the exhibit. And P.O. Klosnick, I could get you a copy of the sheet that I'm showing to P.O. Saunders. Absolutely. I will email you. I can email you a copy after the hearing if that is appropriate. Or
P.O. Klosnick, would you like to see this documentation? What I'm reading here, there was we could send you a copy right now.
My point, I think I tried to point out that 11 o'clock this occurred. I think I spoke to him 2 hours after the fact at 1 o'clock, maybe 2 o'clock. Again, I'm being presented this evidence right now, so I'm not really going through all my records. But the fact of the matter is after I spoke to him and I said you were giving explicit instructions to go to the App Foundation as a graduated sanction, you haven't gone to McCall's. Your GPS report is horrible. We have all these technical violations with you. This is your last gift.
Talking P.O. Klosnick, I was just making sure that I was just checking to see if you wanted to copy the evidence, but if I may continue.
One second, counsel. If you want, I can make a copy and email it to you. I can email it to you right now so you can take it. Oh, no. Okay. So you can finish it.
Yes, thank you very much. So again, I would just note that the medical records I submitted, I think, support that my client was feeling unwell and wanted to be checked out to make sure that he was okay given his medical history. Lastly, concerning the allegations that were incorporated into the PBR concerning my client's girlfriend, I just want to note a couple things. So that individual, Ms. Pulaski, actually did call me at my office, and as a commissioner of the Superior Court, I can report that in speaking with her, she unequivocally stated that my client had never threatened her and she was not fearful of him. I want to make it very clear that when I spoke with her, she said that she never wanted a no contact order with my client or anything of that nature, and felt that if anything, it was inappropriate for parole to step in and contact her individually, encouraging her to have the no contact order. I will just note concerning the Homeland Security situation, I don't want to get too deeply into it because there hasn't really been concrete evidence submitted as to that. But I just want to note that my client's partner works at a federal office, I believe, and there is security on site, just like there are at courthouses and most other, federal and state buildings. And in that specific situation, she indicates Mr. Tripp had showed up at the job to speak with her about the relationship, but she wasn't fearful and indicates he wouldn't threaten her. She was more so concerned that it would look poorly on her that her partner was showing up at her job. So I just want to make that clear. She had spoken to me, I believe it was Friday when I spoke to her at length, and she did, indicate all this. So I did just want to make note of all that for the record, and we would like to talk to my client's background history at the appropriate time. Thank you.
Thank you. P.O. Klosnick, anything further?
Did I recommend a no contact with her? I'm not sure.
It was just in the, I believe in the narrative. What I was referring
It's in
to.
the narrative. They were going to pursue criminal charges, spoke to the victim who recanted and did not want to go further with this. I would feel safer as a parole officer, and I would recommend to the board that if they do add a no contact stipulation with his former sponsor, I don't have the name on me right now, without the PO's permission. Again, we just want to make sure that, he did complete Explore and that there's not going to be any more domestic violence issues. And she did call the police if she didn't feel safe. I don't understand why she did. I had to put an exclusion zone around the Social Security office for his GPS and alert Homeland Security anytime he went there when he was working on the warrant. We have text message in there where it's pretty threatening in nature. I wish I could pull them up, but again, I just, what it boils down to is I would just feel more comfortable with the no contact without the parole officer's permission. Not saying he can't have contact. We do understand they're in a relationship. We just want to be safe about it and make sure that everything is, that we're protected, I guess you could say.
Mr. Jones, did you have anything additional that we didn't already state for the record concerning the charges that you wanted to say at this time? Mr. Jones?
No.
I'm so sorry, Mr. Tripp. I'm so sorry. That was the hearing before this. Mr. Tripp, is there anything that you want to say at this time that I didn't already put on the record?
As far as I have rules on. Yes, Miss, I just don't understand. I feel like everything is being flipped on me. He's saying I'm bribing people to live. I just want to ask anybody, where do you live at for free? Like everything he's saying about me is just like, it's like he's flipping it into something that it's really not. So it sucks to have to sit here and listen to this. I have wrote something pertaining to me. I don't care about what Mr. Kwasnick has to say. I'm worried about me, and I'm worried about my addiction and what I need to handle for myself. If it's the time to speak about that, I'm more into speaking about that, because if I dwell on what this man says about me, and I am who this man says about me, I will amount to nothing. And I really don't want to, like, miss, I really don't even want to talk. It's like really upsetting to me. So if this is the time where I talk about my goals and what I want to do.
So that'll be at the next part of the hearing?
I'll turn it over to you in just a few minutes. Mr. Tripp, we're about to get into the background and history. I'll give my spiel and then I'll turn it right over to you. Thank you very much.
Thank you, Miss.
And P.O. Kwasnick, anything further?
No.
Regarding the charges, okay. Counsel, you need to-
All set. Thank you very much.
Regarding charge 1 GPS, a no finding was made on part 14 at the preliminary hearing held on October 7th, 2025, and there was no further evidence submitted regarding that part. Therefore, part 14 in GPS is not being considered today. However, I do make a finding on the rest of the parts listed in this charge based on 6 exhibits A, C, E, I, and M. Charge 2 curfew, a no finding was made on part 11 at the preliminary hearing held on October 7th, 2025. And again, no further evidence was submitted related to that part. Therefore, it's not being considered today. However, I do make a finding on the rest of the parts listed in this charge based on state's exhibits A, C, E, I, and M. Charge 3 program participation. A no finding was made on parts 6 and 7 at the preliminary hearing held on October 7th, 2025. There was no further evidence submitted regarding those parts to 6 and 7. Therefore, 6 and 7 is not being considered at today's hearing. I now make a no finding on part 2 regarding the September 4th, is that the date? September 4th, 2025?
Yes, I believe that.
So I make a no finding on that date. However, I do make a finding on the rest of the charges listed based on 6 exhibits A, C, E, G, and J. Charge 4 residents, I make a finding based on 6 exhibits A, C, and I. And on charge 4 drugs, or charge 5 drugs, I make a finding based on 6 exhibits A, C, E, and F. That concludes the fact-finding portion of this hearing. Before I make my recommendation, the state as well as your attorney will have an opportunity to speak to your background and history. And Mr. Tripp, you will have an opportunity to speak as well. But I'm going to start off with P.O. Kwasnick.
I think I said everything that I had to say. Just these.
Anything to make up.
Excuse me.
Anything further?
What? I missed it. It cut out. He said, what?
Things that were made up. It sounded like he said. I don't want to quote.
Things are made up. Well, that's why all the evidence is here. If you want me to go through all of these text messages, I mean, I will.
We're at the back. So the charges are, we already made the fact finding. We already passed it.
So, but all right. So, I mean, I think my recommendation in my parole violation speaks for itself. I have no further comments.
And you said you are requesting a general no contact with
The original sponsor. Let me.
Sponsor. Do you have her initials? I don't know.
I do.
Or her name, because it's a general no contact.
Sorry, my while he counsel's making their statement, let me open it up. My case notes is just slow.
Okay. Awesome.
Yes, thank you very much. My client, Mr. Tripp, is 41 years old, born and raised in Waterbury, Connecticut. He reports a strong support system consisting of his uncle, aunt, cousins, his good friend John, and then his 5 children, in addition to his partner. Upon release to transfer parole in September of 2024, my client was sponsored by his significant other. He then successfully completed Chase Center in Waterbury and then was sponsored by his friend. He was a full-time caretaker for Within Reach in Bristol for approximately 2 months until he encountered a transportation issue. He was reportedly given per diem hours. He reports successfully completing Explore in June of this past year. He participated in McCall and had done the following treatment on August 19th. He did a triage call, which is a telephone assessment. He then on August 25th completed an intake assessment, and September 2nd, he did a group session at McCall. I will note for medical history, as I stated, he does have type 2 diabetes. He reports volunteering at a soup kitchen in Torrington with his job Within Reach, where he would help clients with vocals, often consisting of volunteering. He reports that upon reinstatement of his special parole, he would like to be placed in a Waterbury halfway house. He's reportedly eligible to return to the position within reach in Bristol. He's open to all recommended treatment, including successfully completing outpatient substance use programming. And he also hopes to continue volunteering at within reach. I will just note this is my client's, I believe, first violation of this term of parole. And this is a technical violation. I will note there's no new criminal cases here. My client has been incarcerated since September 5th, so approximately 3 months by the time we get to the next board review date. During the time in the facility, he's been doing well. He's had no tickets. I'm asking you consider a sanction for him not to exceed 3 months. And I would just note, I would be arguing against any no contact stipulation, specifically due to my speaking with the alleged complainant and her expressing just a desire to continue having contact with my client and no safety concerns. And Mr. Jones, I'm so sorry, I keep looking at the file in front of me that says Jones. Mr. Tripp, is there anything at this point that you would like to put on the record concerning your background and history?
Yes, ma'am. I have wrote something myself personally just to give you a better outlook of who I am actually. And I just would like to read it if you guys don't mind.
Absolutely. Thank you.
Thank you. I just was saying, I would like to thank the board for giving me the opportunity to speak. I just want to formally apologize and inform you on how embarrassed and ashamed I am for having to be present at this hearing. I would also like the board to know I spent this time self-analyzing where I went wrong and take full accountability for my actions as a parolee. At my preliminary hearing, I honestly didn't like the way I was portrayed as a failure by my parole officer. But everything said about me just gives me more determination to prosper and excel. And my decisions make my dreams reality. And in order to do so, I have to learn self-acceptance. I was in denial about my drug addiction. One reason why is because I'm a role model to my children and I frown upon it. It contradicts what I am and who I am. The period of incarceration I've attended NA and AA and through different speakers telling their story of their struggles gave me a different sense of myself and motivation to face adversity. I'm always going to have obstacles and adversity. It's just how I respond that matters, and also having a plan. And if given a second chance, I will continue my treatment to attack my addiction through McCall Foundation, the app program, and also trying CCAR and getting a recovery coach. And just take it one day at a time, realizing drug addiction is constantly tearing my life apart. Now I'm missing another Thanksgiving and Christmas in my children's life. Once again, it's a time in life where I'm to the point enough is enough and willing to do whatever it takes never to end up in this position again. I need to just move forward. The more I seem to lose, the more I seem to learn. My dreams will destroy my doubts. Under no circumstance is failure an option. I'm sharing the thoughts in my head that truly will work because they're also in my heart. Thank you for granting me the opportunity to speak, and I'm very eager to answer any questions.
Thank you very much.
Thank you.
Council, anything further?
Nothing further. Thank you.
Phil Klausner, anything further?
No.
And I did get your email regarding the sponsor's name.
Okay, great.
So I'm going to make note that PCS is requesting that JP, there's no contact with her without PO's permission. I'm also going to note that you are objecting to that being a condition. So Mr. Tripp, that is ultimately up to the board and their decision if they accept that, if they put that as a condition. But I am going to note that's a request.
I understand, Miss, but Miss, I haven't harmed. I haven't done anything wrong. There's no police report. There was no situation where police were involved at all, for the record.
Okay. And I'm going to make note of all of that on both sides.
Right. So what she's saying is the Board of Pardons and Paroles, when they vote on your case, she's going to tell you the date that happens. They have it ultimately in their discretion whether or not they want to impose it. But all the information that's been put on the record will be available to them.
Yes, ma'am.
I'm going to take a moment before I announce my recommendations. Hey, Mr. Tripp, I see that you were released to discretionary parole back in October of 2024. You were in the community for approximately 11 months. Within that time frame, there are several GPS violation and curfew violations per the evidence and per testimony here today.
Miss, I'm sorry to interrupt you. Might I add, I never had a misconduct or anything until I was in the care of, until my parole officer was Mr. Kwasnik. Beforehand, I never had a misconduct or anything of that nature. Does that matter for you?
Understood. But looking at the evidence provided, there are still several violations for the GPS and the curfew. So I can understand prior to being under P.O. Kwasnik, but looking at the evidence, I mean, there are just several violations regarding GPS. Taking into consideration the program participation, again, I made no findings regarding the September 4th. However, there was some findings regarding you not participating in treatment. The residents made a finding on, as well as the drugs, which is also a concern. So taking into account the testimony here today, as well as the nature of this violation, and this still being your first violation, I recommend revoke and repro on March 5th, 2026, which is an approximate 6-month sanction with the following conditions: no consumption of alcohol, behavioral management for domestic violence, no contact with co-defendants Gary Hall, a general no contact with SD and JP, and a general no contact with JP without the express permission of your parole officer, halfway house placement, and no operation of a motor vehicle without the express permission of your parole officer. So my finding, this is my recommendation, and the board is going to review your case on 12/4/2025. So the board can lower that recommendation, they can adopt that recommendation, or they can exceed that recommendation, being that you remain on supervision until May of 2027. Whatever the board decides, you're going to receive in writing.
Mr. Tripp, I can either set up a legal call with you that day or the following date so that we can discuss what the board decides and go over everything, okay?
Yes.
Thank you very much. We'll talk soon. Thank you.
Thank you, P.O. Kwasnik.
So right now you're recommending 6 months?
Yeah.
Yes, so the Board of Pardons and Paroles, they get the final say. Her recommendation right now is 6 months. That would have you getting out on March 26, 2027, or sorry, March 5th, 2026, sorry. And that will go and get voted on by the Board of Pardons and Paroles. So they have the final say. They could do one of 3 things. They could give you less time, they could give you more time, or they could give you what she's recommending. So we'll know for sure on December the 4th. That's when they meet, deliberate, and announce their decision.
All right, thank you.
Thank you very much.
All right, James. All right, thank you.
Good morning, Mr. Flores.
Good morning.
We're going to get started in just a moment. Good morning. My name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Josan. How do you say your first name?
Josan
Flores, MA number 2999978. Today is Monday, September 24th, 2025. This hearing is being conducted via video at the Board of Pardons and Parole Central Office and Savolsky Correctional Institution. Please state your full name and DOC MA number for the record.
Josan Flores, 299978.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is also your attorney.
Good morning, Peter Matthews, the Public Defender's Office for Mr. Flores.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Flores, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
True.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, your attorney will have an opportunity to speak to your background and history. Mr. Flores, do you have any questions about the purpose or procedure before we begin?
No.
You have important rights to this hearing, which I now will review with you. You have the right to be represented by an attorney at this hearing. You have the right to receive written notice of charges of violation. Mr. Flores, did you receive an evidence packet that had the charges and evidence to support the charges?
Yes, sir. Yes.
You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes, sir. Miss. Please have it.
We now will review the charges of the state your parole officer is bringing against you and the information underlying each charge. Charge 1, drug testing. On May 30th, 2025, you reported to the Parole Norwich District Office and found to be in possession of a bottle with a urine sample in your waistband. On May 30th, 2025, you admitted to using cocaine. Charge 2, obedience to the law. On August 17th, 2024, you refused to leave Parol's Cafe and ignored Willimantic police officer commands to stop running. Subsequently, you were arrested by Willimantic police for interfering with officer and resisting and disorderly conduct. On November 6, 2024, you ignored all commands given by Willimantic police officers and engaged in a foot pursuit. Subsequently, you were arrested by Willimantic Police Department for interfering and resisting. On April 25, 2025, you were involved in a verbal dispute with Francesca Vargas, where you attempted to take her phone by force, and in the process, she was struck in the upper lip with her cell phone. Subsequently, Willimantic Police arrested you for breach of peace, reckless endangerment second, robbery third, and larceny second, take from person. On May 22nd, 2025, you ignored all commands given by Willimantic police officers and engaged in a foot pursuit. Subsequently, you were arrested by Willimantic police for interfering and resisting. Charge 3, drugs. On or about May 26, 2025, you used cocaine. Subsequently, you signed a voluntary drug admission form on May 30th, 2025, admitting to using cocaine. Charge 4, journal no contact. On August 17, 2024, you had contact with Francesca Vargas, according to Willimantic Police report ending in 028. On April 25th, 2025, you had contact with Francesca Vargas, according to Willimantic Police report ending in 190. The state has filed the following exhibits. Exhibit A, parole agreement. Exhibit B, parole violation notice. Exhibit C, parole violation report. Exhibit D, remand to custody. Exhibit E, Willimantic Police report. Exhibit F, Willimantic Police report ending in 807. Exhibit G, Willimantic Police report ending in 190. Exhibit H, Willimantic Police report ending in 021. Exhibit I, picture of urine in a bottle dated May 2025. Exhibit J, voluntary drug admission. And Exhibit K, parole violation reports from May of 2021, January 2023, and September of 2023. The state has filed an addendum to Exhibit C, which states the following. On October 27, 2025, the charges of interfering and resisting and disorderly conduct were nollied under docket ending in 063. On October 27, 2025, Mr. Flores was convicted of larceny second, take from person, and sentenced to 5 years jail, execution suspended after 9 months jail, followed by 3 years probation. The charges breach of peace second, reckless endangerment second, and robbery third were nollied under docket ending in 162. On October 27th, 2025, Mr. Flores was convicted of interfering and resisting and was sentenced to 9 months jail under docket ending in 161. For the PBR, Mr. Flores has no other pending charges. Counsel, did you receive the notice of parole violation report, and the other documents that were just marked for identification purposes?
I did.
And the defense has also filed Exhibit 1, parole accomplishments and future plans for reinstatement. Defense Exhibit 2, letter support from Mr. Flores' uncle. Defense Exhibit 3, letter from outpatient therapist at CHR. Today we have no witnesses. It is now the defense opportunity to present evidence to speak to any of the evidence submitted. Counsel?
Thank you. With regard to charges 1 and 3, this incident occurred the day he was remanded to custody. After this incident, Mr. Flores did admit that he had relapsed on cocaine and acknowledged that the drug test did come back positive for cocaine. With regard to charge 2, the obedience to law charge, the misdemeanor charge is stemming from both August 17, 2024 and November 6, 2024, both nollied by the prosecutor's office after they reviewed the case. I think the addendum one mentions one of those cases, but they both were nollied by the prosecutors. With regard to the arrest from April 25th, 2025, the robbery charge and the other misdemeanor charges were nollied, and Mr. Flores pleaded guilty to the larceny second charge. I would note that the larceny second is not a domestic conviction. It was stated on the record in court at this time that it's not a domestic, and all the domestic charges were not pursued by the prosecutor. He did also plead guilty to 1 interfering charge from May 22nd, 2025. Finally, with regard to the no contact condition, in both cases, the alleged contact between the parties appears to have been voluntary. After his arrest on April 25th, Ms. Vargas did tell the police that she did not want to pursue any charges against him. I would like to be heard at the appropriate time regarding the sanction as well. Thank you.
Thank you. Regarding charge 1, drug testing, a no finding was made as the state failed to provide sufficient evidence to prove Mr. Flores' actions meet the elements of this charge. Charge 2, obedience to the law, I make a finding based on Mr. Flores' conviction, as well as 6 exhibits A, C, and E through H. Charge 3, drugs, I make a finding based on state's exhibits A, C, and J. In charge 4, general no contact, I make a finding based on Mr. Flores' conviction, as well as state's exhibits A, C, E, and D. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney will have an opportunity to speak to your background and history. Counsel?
Thank you. Mr. Flores, he's 44 years old. He was born and raised in Connecticut with his family. His family does reside in the Willimantic area. He has a close and supportive relationship with his family. His uncle did provide a letter, which is attached as an exhibit, where he states that Mr. Flores does have a large and supportive family who do want to help. When he is released, he's hoping to be sponsored by his mother, who lives in Willimantic, and if that's not possible, he would be seeking a halfway house in that part of the state. His brother and sister also reside in that area, along with his 2 children, who he has a good relationship with. His youngest is 4, and he does report seeing her on a regular basis. Prior to the remand, Mr. Flores was working at a tree service company called Down to Earth. He was a tree worker. He was doing this for approximately 1 year. He does report he had a good relationship with his employer, and he's hopeful he'll be able to return to that position when he is released. He also done some work occasionally volunteering with his aunt at the local soup kitchen. He has been on SSI disability in the past due to his mental health limitations. However, he has attempted to work in some capacity and has done well at the various positions he has obtained. When Mr. Flores was in high school, he did attend a school devoted to special education, and unfortunately, he's been unsuccessful in passing his GED tests, despite working hard to accomplish this over a period of time. He really put a lot of effort into it, but so far, he hasn't passed it, but he's still working on that. According to the family members, Mr. Flores was diagnosed with mental illness at a young age, and his family has been working with him all of his life to try to get him the appropriate treatment for his disabilities. These limitations have contributed to some of the poor decision-making and impulse control issues that Mr. Flores has struggled with throughout his adult life. In terms of treatment to address these needs, he did attempt to go through some treatment on parole. He enrolled in the ILP program through CHR. This program was several hours a day for several days a week. It was fairly intensive. A letter from the clinician was attached, which does show that he made an effort with that treatment, and he did complete that program. Unfortunately, he did relapse after this, but he does want to re-engage with the substance abuse treatment program, either at the CHR program or a different program. Parole thinks that would be more appropriate for him. He could also benefit from some individual counseling to address his mental health issues. He's certainly willing to engage in any regular counseling or treatment that Parole feels appropriate, but I think he does have needs beyond simply substance abuse and domestic violence counseling. I understand this is his fourth violation, and the recommendation from Parole is that his supervision be revoked at this time. I would ask that he be given another opportunity to work with Parole after an appropriate sanction rather than revoking his parole altogether. Mr. Flores, he does have a lot of challenges, but he has a supportive family who want him to succeed. He needs some structured treatment and guidance, and will likely need that kind of support even after his parole supervision has expired. As I previously indicated, most of the charges he faced were not pursued by the state in court, including all of the domestics. He will be on probation as well when he's released, so that will be an additional layer of supervision and accountability for 3 years after his release. I would also note that this was an 8-year period of special parole, which is pretty lengthy. So while there have been multiple violations, he has demonstrated an ability to work with parole on some periods of time. He was on supervision on this case for over a year before his remand. I'd also just state, Mr. Flores received a total sentence of 18 years, including special parole for nonviolent narcotic charges back in 2010. This was a very significant sentence, and I don't think he would receive nearly that kind of sentence today, given the way such charges are routinely handled in court. According to the DIS summary, there were no weapons involved in that 2010 arrest, and the legislature did change the law after that sentence so that defendants are no longer sentenced to special parole for nonviolent drug offenses. So given all these factors, I would ask you to consider giving Mr. Flores another opportunity to work with parole after an appropriate sanction rather than revoking his parole altogether. Mr. Flores, is there anything you'd like to add?
I'm sorry for the community, but I know I did wrong. I apologize, and I know I did wrong, but I don't know how to speak little English. That's why I'm a little nervous. But yeah, I'm sorry about it. I can't say no more.
That's all right. You don't have to say anything if you don't want to, Mr. Flores. It's just
Yeah, but I want to know so much English.
Do you need an interpreter?
I was able to speak with him. I didn't think he needed an interpreter when I spoke to him. Are you okay without an interpreter, sir?
No, I'm all right.
Okay. I just want to make sure.
I'm nervous, that's why.
Okay, no worries. Is there anything else you want to say? Are you all set? Okay, thank you. Council, anything further?
No, nothing further.
I'm just going to take a moment before I announce my recommendation. Okay, Mr. Flores?
Thank you.
Okay, Mr. Flores, you were discharged to special parole in November of 2019. Since being discharged to special parole, this is your 4th criminal violation. Taking into account what was said by your attorney today, as well as this being your 4th criminal violation, I recommend revoke and re-parole on November 6, 2026, which is an approximate 1 year and 5 month sanction with the following conditions. No consumption of alcohol, behavioral management for domestic violence, no contact with co-defendant Lionette Rodriguez, Joel Santiago, Juan Mateo, and Emilio Flores, a general no contact with Francesca Vargas without the express permission of your parole officer, and no operation of a motor vehicle without the express permission of your parole officer. My findings and recommendations will be forwarded to the board, and your board review is scheduled on December 4th, 2025. So my recommendation is that a 1 year and 5 month sanction with a re-parole date of November 6th, 2026. The board is going to review your case on December 4th. And on that date, they're going to make a final decision, whether they adopt that recommendation, lower that recommendation, or they can exceed that recommendation because you remain on supervision until November of 2027. Okay, Mr. Flores?
Then I'll come back November.
So you won't come back at all? unless, the only way you come back again for a hearing is if the board doesn't agree and they want to go longer than the recommended sanction.
And then what the date?
So it's another year in jail, Mr. Flores, the sanction. They're recommending you release November 6th of next year. And then you have one more year left on parole.
Wow.
Right, so that is it. Your hearing has concluded, Mr. Flores, but the board makes the final decision.
So they'll make a decision on December 4th, okay?
December 4th, then you're
Yeah.
saying to do a year more after my 9 months?
Yes, the sanction is for another year from today approximately. So it's a 15-month sanction. You've been in some time already. So the recommendation is that, but the board will make a final decision on December 4th.
But one question.
Yeah,
I count I've been down 6 months. I count the year or?
yes, that can it'll be another year from today. The total sanction is 17 months, but it'll be 12 months from today approximately.
So it starts from when you came in. So the 17-month sanction starts in May. You came back in May. So 17 months from May is the recommendation. But the board has the final decision.
So if you want to call us on December 4th or after that day, we'll let you know what the board decides, okay?
All right.
Thank you.
Thank you.
Good morning.
How you doing, guys? He'll be here very shortly, okay?
Thank you.
Okay, you're welcome. That's right, we feel right. But every time you go to move, the way your legs skip away. But it was I was on 6 weeks, no operation, nothing. But it calmed down. Race will help it. I'm just saying now.
Good morning, everyone. It's 9 a.m.
Good, man. Thank you.
All right.
Morning.
Morning, how you doing?
I'm gonna get started in just 1 second.
All right.
Good morning, my name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Antonio Barreto, inmate number 418026. Today is Monday, November 24th, 2025. This hearing is being conducted via video at the Board of Pardons and Parole Central Office and Corrigan Correctional Institution. Please state your full name and DOC inmate number for the record.
Antonio Barreto, 418026.
This is a public hearing. Public access to this hearing is available via video live stream. This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Barreto, please raise your right hand. Do you solemnly swear or solemnly sincerely affirm as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Thank you very much.
Welcome.
First, I will read your rights. Then we will review the parole violation charges that the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. You will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, you will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney at this hearing. If you cannot afford an attorney, you may qualify for an appointed attorney to represent you. Do you intend to seek counsel for this hearing, or would you like to proceed without counsel?
With counsel.
Okay, so if you want an attorney, then we're going to continue your case until December 2nd. And in that time, I will inform the attorney's unit that you would like an appointed attorney to represent you, okay?
All right.
So I'll see you back on the 2nd, okay? December 2nd.
All right. Thank you. Thank you.
Thank you.
All right.
Good morning, Peel Curry.
Good morning. How are you?
I'm good, thank you. We're going to get started 15 minutes right on time.
No problem.
Good morning.
Morning.
We're gonna get started in just one moment.
Okay.
Good morning.
Good morning. My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Virgilio Rosario, inmate number 186413. Today is Monday, November 24th, 2025. This hearing is being conducted via video at the Board of Pardons and Parole Central Office in Bridgeport Correctional Center. Please state your full name and DOC inmate number for the record.
Virgilio Rosario, number 186413.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is your attorney,
Good morning, Hannah Dean on behalf of Mr. Rosario.
as well as your parole officer. Please introduce yourself for the record.
Paula Curry, Parole Officer 2.
This is a preliminary hearing, which has three purposes under Connecticut law. To determine if there is probable cause to believe you committed an act that violated the conditions of your parole. To determine if the act is sufficiently serious to warrant the revocation of your parole. And to determine if you should be held in prison pending further proceedings. The state, not you, has the responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. The testimony at today's hearing will be taken under oath. Mr. Rosario and P.O. Curry, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
I do.
Thank you very much. First, I will read you your rights. Then we will review the parole violation charge that the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. Your attorney, as well as the state, will have an opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of this hearing, I will inform you of my findings, which will be based on the available evidence. Mr. Rosario, do you have any questions about the purpose or procedure before we begin?
No.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. And Mr. Rosario, did you receive the notice of violation, the charges in the evidence packet to support the charges for today?
Yes.
You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes.
We now will review the charges that the state your parole officer is bringing against you and the information underlying each charge. P.O. Curry, starting with charge 1, obedience to the law.
Obedience to the law. On November 6, 2025, you were arrested by the Ansonia Police and charged with disorderly conduct, domestic violence. You are in violation of Connecticut General Statute 53A-182.
And the state has filed the following exhibits. P.O. Curry, starting with Exhibit A.
Exhibit A, Connecticut Conditions of Parole. Exhibit B, Remand to Actual Custody Order. Exhibit C, Notice of Parole Violation. Exhibit D, Parole Violation Report. Exhibit E, Ansonia Police Arrest Warrant. Exhibit F, Preliminary Summary. Exhibit G, Decision Information Summary.
Counsel, did you receive the notice of parole violation report, and the other documents that were just marked for identification purposes?
We have, thank you.
And defense has also filed Exhibit 1, Steel Point article, Defense Exhibit 2, Advocacy article, Defense Exhibit number 3, Court Disposition, and Defense Exhibit number 4, Statement from Maria Martins. Counsel, do you have any witnesses to call for today?
I do not, thank you.
In regards to charge 1, obedience to the law, on November 4th, 2025, A Superior Court judge established probable cause, as well as there was a conviction on this charge already. Therefore, I cannot revisit this finding. However, the state may make a short statement and testify with respect to the severity of the allegations. Peel Curry?
Yes, first of all, I didn't receive the information regarding this disposition of the charges until this morning, so I wasn't made aware of that until today. And in regards to the sponsor's letter, Ms. Martins contacted me several times, told me that Mr. Rosario had stolen her jewelry, had taken money from her. She told me that she was withdrawing her sponsorship and that he was not allowed to reside at her house. And then this morning I get a letter from Ms. Martins basically redacting everything that she said earlier. I'm confused, but so it is. That's what she said.
Anything further in regards to the seriousness of the charges?
She did tell me that she was frightened of him. And when I read the warrant said that she also told the Ansonia police officer that she was frightened of him and he threatened to smash her face in or something to her face, punch her face, something like that.
Thank you. Counsel?
Yes, thank you very much.
1 second. I just want to just reiterate that in regards to charge 1, obedience to the law, probable cause was established as well as a conviction. Therefore, I'm not revisiting this finding. However, defense may make a short statement and testify with respect to the severity of the allegations.
Sure, thank you very much. Concerning the charges, I just want to note my client, as noted, was able to resolve this matter on November the 7th with an unconditional discharge. No time to serve was imposed. Concerning the seriousness, I would argue this conduct is not serious enough to warrant revocation of my client's parole. First, as noted, he did receive an unconditional discharge to 1C misdemeanor charge, which resulted in no time to serve, no probation. I would argue this shows clearly that the court and the prosecution did not think this conduct was serious enough to warrant a harsher penalty by any means. I also want to note that the defense's submitted exhibit from Ms. Martin, I believe, indicates, again, she's not fearful in any way of Mr. Rosario and indicates that he never threatened her. Additionally, I would argue that Exhibit E, submitted by the state, which is the Ansonia police report, I believe corroborates Ms. Martin's statement. As you can see in paragraph 9 of that report, Ms. Martins reiterates to the police that she was not fearful of my client and that he did not threaten her and that she did not wish to press charges. She indicated that all of the items taken were subsequently returned from her, and she did additionally indicate that she was emotional at the time that this, initial contact with police occurred, and confirmed, however, that she was not scared of my client. That's all included in paragraph 9 of the police report warrant. Lastly, I think in considering seriousness, it's also important to speak about my client's background, the way he was behaving while on parole, just to put into perspective what he was doing. My client has accomplished many things on parole, which I think are really kind of nothing short of remarkable. He was released to parole in June of 2021. He got right to work on bettering himself in his community. He started his own business, Rosario Resource Group, that same year, where he does landscaping and offers employment to formerly incarcerated individuals who need help getting back on their feet and acclimating back to the community. My client developed many relationships in that position with career resources in the area, in addition to building up a series of community relationships with local businesses. He eventually scaled up his business and became a general contractor. He then established an LLC called Waterfront General Contracting. In that role, he helped small businesses to take larger jobs from companies and municipalities to help uplift his community and keep business in Bridgeport. He has been recognized for these efforts with Steel Point. That was the article we submitted in Exhibit 1, and has received a number of accolades for his hard work, his community building, and his advocacy for community and formerly incarcerated individuals. His work, I think, has continued to evolve over the years, with him taking on bigger and better roles. He created an anti-bullying program for the middle schools in Bridgeport, where he goes in and speaks to the youth. He reports working with the chief of police in Bridgeport to explain issues specifically related to substance use and addiction, in order for the police to have a better understanding of the disease coming from somebody with that lived experience. He's volunteered his time giving out food to the community with Easter NRC on Thanksgiving to low-income families. And most recently, my client earned a scholarship and got back to school at the University of Bridgeport, where he's working on a bachelor's and is majoring in business with a minor in psychology. Additionally, I would argue one of my client's biggest assets is that he comes from an extremely supportive family. His relatives, including his brother and his 3 adult children, are all professionals, and they hold him accountable. They want to see him better himself. They want to see him continue to grow and succeed. So I think that, he does have a very strong support system. I know in the letter, Ms. Martins indicates she is very eager to have him home. And I do just, want to note that I think his background and history really speak for itself. He is, I think, kind of the ideal parolee and is, at his core, a go-getter who wants to do better and wants to uplift the people and the community around him. Mr. Rosario, is there anything that I missed concerning your background and the seriousness of the conduct here?
No, thank you so much for sharing a little bit about the things I do, and I just want to get the opportunity to continue doing, and it's been a wake up call for the way the seriousness of being on special parole, and I take full responsibility for any misbehavior that I may have shared or expressed. And I know I want to apologize to Ms. Curry specifically because I was upset with the initial revocation besides this, and I was real angry expressing myself. I was, being taken from my community, come back to prison. I haven't been in prison in 5 years, and it's kind of strange because I thought I was doing great. But other than that, thank you so much for giving me this opportunity today. And I would like to just get back to my community because Thanksgiving is right upon us, and I want to participate in a couple of activities giving back to the community of the homeless people. And that's it.
Thank you very much, Mr. Rosario.
Phil Curry, anything further?
Yes, on September 10th, my supervisor spoke to Ms. Martins, and Ms. Martins stated that Mr. Rosario had relapsed and he had stolen her jewelry. He also took a box truck from her. She was going to call the police. I spoke to Ms. Martins on the 18th, and that's when she withdrew her sponsorship. She called me again a second time on the 18th, and she reiterated to me that he had taken her $10,000 chain, taken money out of her pocketbook. Her box truck was missing and her vehicle was missing, but she did recover her box truck. She found it in Bridgeport. She told me at a mechanic's garage. She also filed 3 police reports regarding that incident. That all fell into place with the fact that Mr. Rosario had been inapt for a while, in 2024, July of 24 until August of 24. He had been in the APT inpatient residential program. So Mr. Rosario has had issues with relapsing and with drugs. He also failed to report to me as I asked him to report to me on September 18th. Then he was remanded. When he did report in October, I was unable to locate him. I called his daughter, I called his brother, and any other phone number I had for him, and nobody would return the phone call to even tell me that they had laid eyes on him. I had no idea where he was for several weeks in the community, and which is why Ms. Martins told me she was withdrawing her sponsorship. He had no DOC approved sponsor in the system, and that's another reason why he was remanded back in October.
Thank you, Counsel.
I would just note for the record that all of the information just put on the record by P.O. Curry was already part of a prior revocation proceeding back in, I believe, October. I will also note that at the preliminary hearing, a number of the comments that she made, there were no findings made for, such as the absconder and the residence charges. But I would just note that these were already all considered at a preliminary hearing, and currently right now, at this hearing, the only thing we're considering is that one obey all laws charge. Secondly, I would just again reiterate that Exhibit E, I think kind of in paragraph 9 has probably the more updated, contact with the complainant, who I think again reiterated that all items have been returned. She did not wish to press charges in any way and was not, fearful or threatened by my client. Thank you.
Thank you. Feel for anything further?
No, I'm good. Thank you.
Okay, I'm going to take a moment before I announce my findings and recommendation.
Thank you.
Hey, Mr. Rosario, I see based off of a defense exhibit number 3, you were convicted of disorderly conduct on November 7th, 2025 and received an unconditional discharge. Regarding that charge, so I do make a finding. Well, the finding was already made because it's established, probable cause was already established by the court by 1, a warrant, and 2, you received a conviction. Therefore, I'm not revisiting this finding. However, I do want to put on record there was a conviction for disorderly conduct, and you received an unconditional discharge. Taking into account the behaviors that led to this conviction, I do find that the acts are serious enough to warrant revocation, and I have also determined that you should be detained while you wait for your revocation hearing. Your revocation hearing will be scheduled within 60 business days from your return to custody. So you're going to receive a disposition that has a tentative hearing date, and you'll be heard again at the revocation hearing at that time. But again, keep in mind that that date is tentative and it's within 60 days of your return to custody, and you came back in on November 6th. So it'll be within 60 business days from this.
So Mr. Rosario, she's recommending that you remain incarcerated until we get a revocation hearing. I will update you as soon as I get a date for that. And regardless, you and I will be speaking shortly to kind of debrief everything and prepare for that second hearing, okay?
Okay.
Thank you very much.
Thank you.
Well,
Thank you, Pio Curry.
Thank you.
A great day.